Well, good morning, everyone. Welcome to a new ForoCompetencia breakfast. We have the honor today of having Mariana Tavares that will be initiating the debate on competition compliance, which is a topic that is very dear to all of us, and since it has been growing significantly in recent times. Mariana, the floor is yours.
Thank you so much, Mariana, and thank you for the invitation. It's really great to be joining such a distinguished group today to discuss developments on antitrust compliance in Latin America and in Brazil. So to kick off our discussion, I thought I'd cover three topics. First is the evolution of compliance regulations and relevant precedents in Brazil. Then move to consider a potential, whether there is a potential connection between compliance and strong enforcement. And then finally draw your attention to what, in my view, is probably the most relevant development on this subject in a while, which is the survey carried out by the ABA and Chile SECO on compliance in the region. And of course, I would look forward to your comments, reactions at any point, and certainly after that. And so to our first topic then. The key rules on antitrust compliance in Brazil are CADE's 2016 regulation on compliance program, antitrust compliance programs, the 2017 guidelines on settlement, and interestingly, also the anti-corruption regulations issued by the CGU, which is the anti-corruption authorities. These, although focusing on anti-corruption, they also cover potential antitrust violations. And in fact, today, most compliance-related efforts by Brazilian authorities in the spotlight and known to many of you are on anti-corruption. This is a result of the Clean Company Act and the statutory development since 2014. And these rules introduced strong investigative tools and also promoted compliance programs. But also its most famous result, the car wash investigation. The truth, though, is that compliance initiatives have prospered in Brazil in numerous other areas, and this has been the case for quite a while. For example, over 20 years ago, the National Monetary Council issued a regulation that promoted compliance in different areas such as money laundering, preventing terrorism, and systemic and prudential risks in the financial sector. And just a few years after that, in 2004, the investigative agency at the time, the SDE, issued Ordinance 14 that for the first time set forth guidelines for compliance program in Brazil. 12 years later, then we get to 2016, CADE published the rules, which are very comprehensive, very easy to read manual. And the guidelines set forth that effective compliance program with damage control measures that are based on the 5 well-known pillars. That program needs to be tailor-made. There must be training, tone from the top, oversight, and sanctions for non-compliance. That such a program may be considered evidence of the company's good faith and of the program being able to alleviate harmful effects of the conduct under investigation. And these programs, therefore, may be viewed by CADE's tribunal as a mitigating factor when calculating fines and settlement sums. And this, in my view, and we'll get back to that when we discuss the compliance survey. Here, in my view, is where there is room for improvement, because none of the guidelines or the case law that we have so far, and we do have some interesting case law that I'll refer to you to in a minute, none of them set clear guidance on the calculation of the discounts to which a defendant may be eligible to if they have effective compliance programs. So this is the current status of compliance regulations in Brazil. And it's interesting to consider the evolutions of these rules in contrast in light of CAGI's precedents during this time, and also in light of enforcement, and I'll get back to that shortly. So we have the 2004 rules and the 2016 guidelines, and on substance, these sets of rules are similar. No, clearly the 2016 guidelines are an enhancement of the compliance framework. It provides, it's much more detailed, and it's a clear step forward in the sense of enhancing transparency and legal certainty. But the 2004 rules already provided that companies with effective program could be eligible for discounts over the applicable sanctions. But then we had the 2004 rules, and in fact, right after that, 3 years later, in 2007, we have the first two decisions where CAGI acknowledged the importance of compliance programs. First, it was in a ruling against defendants found guilty of entering into agreements and of unilateral conduct in the medical segment. And this case is also, so this is the first case in 2007, and this case is interesting because it was the first time. So, and after the CAGI issued the decision, one of the defendants filed a motion to clarify, asking CAGI whether which company should adopt a compliance program, because that company, in fact, already had its own program. And CAGI clarified that the decision applied to all defendants, but that each could decide on whether to follow it or not, because with respect to that, the decision was a recommendation and not a determination to all defendants. The second case, we're still in 2007, was a settlement execution in connection with a cartel investigation in the cattle industry. And this settlement included a commitment by the defendants to adopt a corporate compliance program with the goal to prevent employees and related third parties from violating the law. And this case is interesting, and we're in 2007, and it was the first time that CAGI already made clear that its expectation that compliance obligations should also extend to related third parties. But it was only after the 2016 guidelines that CAGI introduced that after the introduction of the revised rules, that CAGI actually began rewarding companies that commit to implement robust programs, rewarding, and so giving out discounts to companies that committed to implementing a robust compliance programs. And this follows a trend that was introduced by the Clean Company Act in 2013, came into effect in 2014, and already in place in many other jurisdictions. Since then, in at least 10 settlement cases, CAGI granted 2 to 4% discounts to defendants that agreed to implement compliance programs, and in different sectors, in healthcare, in real estate, in mail, construction. So it's we have quite a broad range of companies that were eligible to discounts because they agreed to implement robust compliance programs. And all these discounts were granted for companies that acknowledge that commit to adopt future adopt compliance programs, or to enhance their compliance programs, but not in view of existing arguably effective programs. So discounts over fines to defendants found guilty for violating the law for ex ante compliance programs have never been granted. So what we normally see here is a combination of fines plus the obligation to introduce a corporate compliance program. For example, we saw that in the LPG cartel case and in the type C milk cartel case. And in this last case, the milk case, the determination included the adoption of not only antitrust compliance program, but also anti-bribery policies. And so arguably, CADE went away its statutory authority, but also extended the obligation to anti-bribery. So we have that in the context of cartel cases. We've also seen that in the context of unilateral conduct cases, and in at least 4 merger cases, 2 of which after the 2016 guidelines. And a year ago, for example, in a merger case in the cattle industry, one of the commissioners emphasized the program the importance of the program, and that its positive effects would extend beyond the term of the settlement between CADE and the party. So it's a clear indication by CADE of the importance that it awards a compliance program. A recent trend that we've noticed over the past few years is that CADE, in this evolution, is that CADE became more active in monitoring such obligations. And one of the things that it has been doing is that requiring that the parties engage external monitors. And these external monitors assist CADE by submitting periodic reports and expert opinions about the programs. The review that CADE carries out typically focuses on the scope of compliance programs and whether there are hotlines, external and internal hotlines, whether there are training, whether there are manuals online and things like that. On a separate note, I mentioned the case that where CADE included the expectation that anti-bribery policy should also be covered on its compliance programs. But we also see that the other way around. The CGU, the agency responsible for prosecution of corruption cases, it has also encouraged the adoption of competition compliance programs. They have entered into at least 17 agreements, and in around 15 of them, at least, there are provisions regarding competition policies. For example, parties have been specifically asked about what their competition compliance program policies look like. They are required to carry out training session and also covering antitrust and adopt other tools to ensure compliance with antitrust and public bidding laws, and such as having employees sign compliance representations. And we see that in statutes as well. We have a new public bidding law since last year, and it provides that defendants may be eligible to discounted fines if they agree to, enhance or adopt compliance regulations. But the criteria that it sets forth, and again, we're talking about a public bidding law, not a competition law, the criteria underscore the need to comply with competition requirements as well, excuse me. One point that I believe is key regarding the implementation of compliance program, and this is our second topic today. Don't know whether I saw that Eduardo Perez Mota was registered. I don't know whether he has joined, but this is a point that we covered in the great panel that Eduardo moderated in the spring meeting this year. This was the question that he posed on whether there is a direct connection between compliance program, implementation of compliance program, and strong enforcement. And in my view, and I hadn't actually thought about this before the survey, which we'll get in a minute, and about this, and after and before this question. But I see that there is a direct connection, and from different angles. So, for example, from the agency's perspective, I think that's the direction is clear. At some point, and I'm talking about Brazil, but I believe this holds if we're looking at other jurisdictions too. So at some point, the agency acknowledged that having in its toolkit only sticks would not do, that they also needed carrots in their toolkits. And from the company's perspective, on the other side, after they realized strong enforcement, they very quickly began dedicated substantive resources to prevention to avoid violations. I mentioned to you Ordinance 14 that set forth the first rules on compliance programs, and the ordinance was issued the same year that the SDE ran its first dawn raid, and the first and just a few months after it executed its first leniency agreement. Since then, well, for 10 years now, but then we had the 2000 and the May 2012, the current antitrust law took effect, and the law introduced key legal changes, including increased sanctions for cartel conduct, revised sanctions for cartel conduct, both at administrative and criminal side. And over the past years, there have been a consistent improvement of enforcement policies on price fixing, bid rigging, but also exchange of information. CADE has turned its attention recently to, over the years, to unilateral conduct. And so enforcement was on the rise, or has been on the rise for a while. Since 2018, CADE opened over 100 investigations, many through leniency agreements. So there is significant evidence of enforcement over the years. We don't have statistics on the impact of the 2004 rules or of the 2016 rules on the dissemination of compliance programs. We don't have numbers. So what happened after the 2004 rules were introduced, and what after the 2016 rules were introduced? But it seems from what I hear and from what I see, I think it's fair to assume that its existence, combined the existence of the rules, of good rules, informative rules, combined with strong enforcement, and also with the outreach initiatives that have been carried by the agency, that this encouraged Brazilian companies in general to adopt such programs. As a practitioner, like many of you, I have worked on different compliance projects for clients, like manuals, trainings, internal investigations, review of different business practice, sometimes revising rules from companies outside Brazil, sometimes drafting these rules from scratch. And since I joined the firm 11 years ago now, I saw a consistent increase in the demand for these services, and that they became more sophisticated over the years. And I remember at some point it was, I won't say common, but it happened in a number of cases that we ran such comprehensive compliance exercise that some included mock dawn raids, in addition to very thorough document review. And many of these did not necessarily uncover violations, but they helped fine-tune, enhance the compliance rules already in place. And I don't want to end this topic on a low note, but I haven't seen such comprehensive projects in a while. there are possible reasons for that. And it could be that one of them, that many companies already have effective programs. So part of the bulk of the work has already been done. So at this point, because there are already effective programs that fulfill that are in line with the key pillars. So they're specific to the industry. They have been. There are the tone from the top is clearly there. Sanctions, monitoring, training. So they already have that. So right now, what there is to be done is just fine-tuning, updating in light of recent laws and more training, consistent training, of course. And so these measures, these maintenance measures should be viewed as enough. So this is one possible reason. Another, and this group has been discussing this in different forums here as well, is a decrease in leniency and in international cartel investigations, and a related perception or a related misperception that enforcement is not strong. And a third, and this is, I don't know if fortunately or unfortunately, but I think it is specific to Brazil, are the reversals in court of major rulings in the car wash investigation, and the perception that it was a fluke, it was a peak in the numbers and of cases, and that and this may lead to the conclusion, or possibly wrong conclusion, that concerns about anti-corruption and anti-cartel enforcement were overrated. I don't have a definitive answer with respect to that. I think I think that that it may be a combination of the three. I certainly think that the fact that many companies did a significant effort right after enforcement began strongly, I think this would explain, and it would be reasonable, because compliance programs are very costly, that what you do after that is maintenance, good maintenance, but with a more targeted scope. And definitely not to end on a low note, what I had to discuss initially this morning. The third and last topic I thought we would discuss today, I would like to draw your attention to what I think is an extremely valuable survey carried out by Eduardo Perez Mota and Felipe Irarrázaval on behalf of the ABA Compliance and Ethics Committee and the Competition Center SECO of Adolfo Ibáñez University of Chile on compliance programs in Latin America. If you have not read that yet, I strongly encourage you to do it. It's available on SECO's website. Felipe and Eduardo did not ask me to do the marketing. I'm doing this because I really think it's a very useful, very important document especially for us practitioners in the region. It is the first study on the status quo of compliance programs in the region, and on how the jurisdictions are doing in the dissemination of the programs. To do the survey, the ABA and SECO interviewed 60 practitioners and the enforcers of 7 countries. Argentina, Brazil, Chile, Colombia, Ecuador, Mexico, and Peru, and contrasted the perspectives of practitioners and enforcers on specific topics regarding the rules and the precedents, the specific aspects of compliance programs, and of the complexity of the programs in place, and the perception of practitioners on the importance or effectiveness of these programs. This is not supposed to be a spoiler of a program Julian may want to host Felipe and Eduardo, but I think preparing for the session, I thought I would be remiss if I did not mention some of the extremely interesting conclusions about in the report. One common perception was that compliance programs in the region are important for agencies, practitioners, and the companies that are advised. So what I mentioned, I think that what I reported to you, what I discussed with you with respect to Brazil is common to other jurisdictions as well. There is a common perception by the agency. They are indicating that they think it's important that the enforcer, the practitioners that advise their clients, and also the demand of clients for the programs. So this is, and there's also a perception that this has been increasing over time. So there is, the increase is upwards. The survey also refers to some areas where there are the interviewees thought that there would be room for improvement. Two critical ones, and this is consistent with what I shared with you in the beginning. My view in the beginning about where there is room for improvement is that, and I think, again, this is not specific to Brazil, is that there is a view that further detail on the compliance regulations or the precedents, or how the agency is enforcing the rules on the applicable benefits to have effective programs. So we know what that discounts are awarded to companies that have effective compliance programs, but we don't see enough. There is some guidance, but not enough guidance in the rules or on the regulations on how this assessment is made, and how a discount, for example, of Brazil is calculated from 2 to 4%. The other one is on the scope of professional secrecy with respect to compliance program. There is a common perception that this needs to be strengthened to enhance compliance. With respect to substantive elements of compliance programs, there is reference to fine-tuning the requirements for compliance officers, incorporation of periodic reviews and audits. And then one that I found especially interesting was the involvement of economists in this exercise, and I tend to agree that this would be useful, and also the use of other technologies and screening techniques to design and to implement programs. Of course, there are, and this is saying not the report, there were costs involved, but the general view was that this would be positive. So this is what I had to kick off our discussion. Again, Julian, thank you for the invitation. We would look forward to any reactions you have.
Perfect. Thanks, Mariana. Very complete. Now we open the floor for any comments, questions, or criticisms to Mariana's presentation. Esteban.
Thank you. Gracias, Julián. Gracias, Mariana. Nice to see you here. Very interesting presentation. I think it's a relevant issue. And I want to ask about one of the last topics that you mentioned is related to the economist participation in compliance programs. In your experience, mainly in Brazil, what do you see about this involvement of economists? Because I think in some kind of new and updated programs, participations of economists have been increasingly important, mainly in screening mechanisms and also in methodologies for pricing rules and compliance by design. So what do you see is happening in compliance programs now, mainly in your experience?
Thank you so much, Stefan, for bringing this up. I think this is, I think it's extremely important. I think it's actually this the way forward. I think that I've seen this in a few cases, but not enough cases. I think that, and I think understandably so. So many. So the first, I think the first step was to either implement a compliance program, effective compliance program domestically, but in many times this involved adapting the programs from other jurisdictions to Brazil. So economists were either involved before I got involved, but there were not economists involved in that stage of importing and adapting compliance program to Brazil. But I definitely think that having economists, if you're especially if you're implementing a program from scratch, will help you comply with the 5 elements that are according to which you have an effective program. It will be you will most certainly be able to tailor the needs of the program to tailor the program to the needs to the company. You will do that in the most cost-effective way, and you will and monitoring will also be more effective. I think it now that in the second stage where companies will in Brazil companies in specific countries are implementing either domestic programs from scratch or fine-tuning the existing programs, that would be a good way forward.
Thank you.
Federico.
Thank you, Julian. Hi, Mariana. How are you? It's nice to meet you. Nice to see you and to hear you again. Just a very short question. You mentioned that CAGI started working with some kind of monitoring agents or something like that that analyze the effectiveness of the compliance programs. I never heard about that. How was the reaction of the companies about this? And as I believe, companies will have to pay for this expert's opinion. And the other question is if there's any of these opinions open to the public, if we could reach them.
Hello, Federico. Thank you for the question, and also for allowing me to clarify. It's the way CAGI does. It's requires the companies to adopt effective compliance programs, and to do that they engage a monitor. So similarly to what happens in the context of a merger, where there are remedies imposed, where you have to involve a monitoring trustee, for example. So we will involve one of these companies to monitor the implementation of your compliance programs. But you're right, there are costs involved. So I wasn't involved in the first case, but there's always this it's a debate of where do we really need this, how much this is going to cost. But I think it's an understandable measure, an understandable requirement on the part of CAGI, because you will have some expert doing the work that CAGI would have to do. So would assist CAGI in doing its work based on reports that otherwise CAGI would have to do, maybe through its economists or through one of its case handlers. So it's but just to be clear, it's not an agency, but you're right that there are costs involved, and you have another third party doing the work to assist CAGI. There are the decisions that the cases that I mentioned today are, I can send you the outline that I prepared for the ABA spring meeting. There are references to these cases, but most of these discussions are redacted. So there will be some reference to what I just discussed, but there are specific sections that are confidential or are redacted from the public case files.
Thank you, Mariana.
Grazie.
Yes, thank you, Mariana. Thank you, Julian. So I have now I have two questions, because further to what you said about measuring the effectiveness of compliance programs, I wanted to ask you, I mean, who has the burden of proving that the compliance program is effective? Because if you say that it's a cost for the company, and then this means that the CADE will not have to run this effectiveness test, then I was a bit confused, because I imagine that when a company brings forward a compliance program as a defense or as an argument to reduce fine, I mean, they have to prove themselves that it's effective. So this is my question. And another question, it's about the private enforcement. You said that there is a decline in leniency requests. This is also the case in Europe. In Europe, they say it's because of private enforcement. As you know, we have a directive since 2014, and it has been developing in Europe, and they say it's because of this. There are no, I mean, the OECD has some data saying that there is no direct correlation, whatever, but still we believe this is the cause of this decline on leniency requests. I wanted to know, in Latin America, in Brazil, Argentina, I mean, if you also see this trend. I guess you don't see it that strongly, because private enforcement, I guess, is not that developed in Latin, but I just wanted to know if you see this correlation, and also what is the impact of private enforcement, if any, on compliance programs and the development of compliance programs in companies. Sorry, that was long.
Great questions. Thank you so much. Starting with the first one, just on the mechanics of how it works. First, short answer to your question. It's the private, it's the defendant's burden to convince CADE that their compliance is effective. But it's the way CADE assesses it. So the way it does is that they issue a recommendation that either you have a compliance program that needs to be enhanced, or either you don't have a compliance program and you need to introduce one. And you will have to submit periodic reports to CADE that you're complying with their decision, with their determination. Before, the parties did that themselves, and CADE carried out the assessment. Now the parties do that, but they also engage an external monitor that prepares reports to CADE. There is, of course, an interaction between the monitor and the defendants, so the monitor receives input for them to assess the program, but ultimately whatever whatever is submitted to CADE is the defendant's is a result of the defendant's efforts, and these efforts have to be viewed by CADE as sufficient, as adequate. On your second question, I think I need to do some publicity also for two panels for the cartel workshop in Lisbon, where we will discuss some of that, and the IBA conference in November, where there will be where I'll moderate a panel on private enforcement, and we'll discuss trends in Latin America as well. That question, let's say, is so I think that question can be covered in two panels, not even in one panel. But I'll give you some reactions. I think private enforcement is an issue may be one of the reasons for leniency going down generally, but it's certainly not the key reason, at least not direct reason in Brazil. Private enforcement has been on the rise, but there are 40 or so cases where there are decisions at the first level court. So there aren't, to my knowledge, final decisions in this area. There have been settlements outside court and in the context of court decisions. But it's not in itself a strong factor, except for the fact that there is, and this is relevant, uncertainty with respect on how this will evolve. So it's something that when we advise clients on going in for leniency, it's a question that we have to be prepared to answer every time. And the reaction is, so I don't really know. So it's certainly something to consider in the balance. But I think with respect to Brazil, this goes into the bucket of uncertainty, and I think there are other uncertainties that may be carrying at this point more weight, such as the fact that CADE is revising some of its elements to some of its criteria to calculate damages in cartel cases, to consider also consider the benefit accrued from the conduct. There is some level of uncertainty on how this will impact cartel enforcement program in general. It was just to be a little bit more specific. This was one vote of the reporting commissioner in a decision. Well, there is this trend, and there is one specific decision, one specific vote by one of the commissioners, of what the reporting commissioner in this case is where this commissioner pointed out found that in his opinion, if you enter into leniency with CADE, you have to be whatever you provide in terms of cooperation needs to be sufficient for CADE to impose fines against the defendant. So you have an obligation with respect to the results of the investigation. This is, I'm covering a lot, so I'm trying to answer your question, but to summarize, some of private enforcement, I think, is an element. I think the decrease in number of applications in other jurisdictions, and some will refer to private enforcement there being the reason, others will refer to Acperia and to changes through the US leniency policy. But I think there are also, some precedents and some policy discussions in Brazil that may have a stronger impact at this point. Private enforcement is definitely an issue too. Hope this was
yes,
clear.
thank you.
Antonella.
Hello, do you hear me?
Yes.
Yes.
Hi, Mariana. Thanks so much for this conference. I'm speaking from Ecuador as a practitioner, and my question comes from, despite we have as many clients that are willing to put all the efforts and resources into designing and putting into practice a complete compliance and antitrust program, there are also many clients that they don't have either the resources, or they don't want to put as many resources as it takes to develop a comprehensive program. What would you suggest to all these cases that want this compliance program on a budget? Like, what should be the basics? And do you think even this basic program will still have any sort of effect? Or is better just to leave it out? It's not mandatory in Ecuador to have one. So what is your thought on this?
Thank you, Antonella. And we get this question a lot. It's especially from domestic companies that are considering kicking off compliance in the company. And even larger companies, costs are always a key concern. And actually, there is an important debate on when, at which point it's cost effective, because it can become so overwhelming that the costs, you have to consider whether the costs are paying off. But so I think this is an answer. This is an answer that is required every time. What we, and a concern every time. So what we do in practice with respect to introduce, when we're faced with a situation where we have to introduce a compliance program for a small company on a budget, we usually focus on a manual that is easy to read and on training. This is relatively easy and relatively I won't say inexpensive, but that you can manage on a budget, because many of the rules you have to fine tune to the specific companies. But the do's and there are a number of do's and don'ts that are not so specific. And then training considering the specificities of the company. So these are two that are on a budget, I think, that most companies are able to do. But one thing, and one challenge that we see is that you say that they retain you to do a compliance program and training, but then you do the first training, and because the legal department is sometimes one person that has to deal with different other subjects, it's they not necessarily they not always come back for the second year. And if that doesn't happen, then you won't have an effective program. So it's very important to be realistic with the client and say, look, you can have these rules, and you can have and you can have training. Then you'll have an effective program. But if you don't keep doing that every year, people will forget. You will have a turnover of people, and the message will be lost. So it has to be a consistent commitment to keep it going. But I do think you can do it on a budget. Other measures, such as having a hotline, that's more costly, and depending on the size of the company, it may be that they may feel that it's embarrassing. But having a manual, publicizing the manual, and having training, I think a lot can be accomplished by doing that, and you can prevent a lot of headache.
I have a question.
Thank you, Mariana. Thank you so much.
Before I give the floor to Javier, well, Javier, go ahead.
Thank you very much. Thank you very much, Mariana, for the interesting talk. I think we've been discussing many of the main points about compliance, but my question is about incentives. We haven't spoken that much about incentives. Most of the things that we do in companies is basically, as some people say, is paper and preaching. So it's basically talk and trainings and training next year. We're competing with many other areas of risks in the firms. Many other areas that demand quite a lot of budget as well. In one single area of compliance. What about the power of incentives in there? How do we apply incentives within a company? Do you know any company in Latin America that applies that apply incentives for compliance purposes? Let's say if I'm going from one layer of management to the other one, I have to show some practical, practical knowledge of compliance or something like that. You know what I mean? It's just talking about the incentives generally. I think we don't talk that much about incentives in Latin America, and And I think that is an important question. So I would like to know about your knowledge on this area in particular.
Yeah, competition is tough, even to have people focus on competition, right? It's if you have to do training on numerous other areas, and I think it's you really have to have a compelling reason for people to do it. I know that it's mandatory that many companies have set this as a mandatory requirement, and it's that I don't recall the specific rule, but it's part of an assessment in large companies whether all the trainings have been followed. But I think what you're getting at is actually a more sensitive issue, because you can have you can turn on an online program on training and then go somewhere, leave it on, and while you do something else. Even if you have to answer a Q&A, it's many people that have done one before may get sufficient answers right to have it done with. So just having a stamp that people did the training is not will not do the trick. So the thing about, I think that the real issue about incentive is has to do with tone from the top. So if it is perceived as a strong issue in the company, most likely people will take it seriously. But also with a very maybe not as important, but I think it makes it easier if you have some resources are spent to make the training useful and interesting. So what we see, for example, in conferences like these the surveys, where you have to you're asking questions while you are while the presentation and while the panels are going. It's and there are votes. So making it interactive, having the quiz. So I think it's more and more, because we have to compete with other areas where training are required. It's critical that we revamp the training materials, like doing a PowerPoint presentations with 45 slides on the relevant rules and on the enforcement record will likely not do the trick. Even if you get people to attend, they won't be paying attention. But so this is the second aspect. But I strongly believe that tone from the top is the number one requirement, and this in turn has to do with enforcement. People need to be worried that something will happen if you don't comply with the antitrust law.
Esteban.
Thank you. After Federico's question, and I was thinking in an issue, and when Javier talked about the incentives, I decided to ask, maybe it's a practical question about the incentives in Brazil, because when you, or when companies think about compliance, always have in mind the probability of detection and the amount of the fines, but this is ex ante analysis. And in an ex post analysis, when a company has been investigated and an anti-competitive conduct has been detected, that the company has the possibility to make a commitment or TCC, I think in Brazil, is like settlement. And in this way, I understand that one of the things that the company can offer is to adopt a compliance program. So in terms of cost-benefit analysis, maybe if the cost of this program, including the reports or audits from external trustees, etc., is an important element. Maybe the company will have the incentive to offer this if the reduction in fine is higher than the cost of implementing this program with a forward-looking perspective. I don't know if I am interpreting correctly the actual benchmark or rules in Brazil.
You are, and I think this is an extremely important point that that should be considered in CAGI's assessment, because the incentive has to be more compliance and more compliant, so it's and also as a result of deterrence. So if it's something that you think that, well, I'm not going to do that because in case I'm caught, I have something up my sleeve that I can offer and get a discount, and so I will actually have to have paid less by violating the law and then having something to offer than if I do right from the beginning. So this can't be the incentives cannot be those. The incentive has to be, I'm going to do good from the beginning, then I won't violate the law, and I won't, because even if I do get a discount, I will be paying more than if I introduced an effective compliant program from the beginning. Then do it right. Do have the right rules, the monitoring, the fine tune it to your company, and etc. But I think that this may not be, I'm thinking as I answer your question, this actually may not be as sufficiently clear to the companies, and if CAGI spells out in its rules and in its decisions how this calculation is made, then they will help make more clear that don't go that way. Don't try to save costs by not introducing a compliance program. Then once you get here, you have it up your sleeve and you'll get a lower fine. That's not it. It's just that it's something that we will offer after you're here, but it won't be. You will be better off if you don't even have to come here.
It can be a tricky and complex issue to align incentives in this way.
Oh yes, all the time, and that's why I think that it's I think CAGI has been doing a great job with respect to showing it considers compliance important, and it's been doing that consistently for 18 years. So I think it's great, and I think it has improved over time, but it's a work in progress. And I think the step right now is to make clear how these discounts apply on the one hand, so that you don't, so that people don't get the misperception that it's actually a bonus and not a sanction. And the other thing is enforcement. If there is no enforcement, I think there's a good chance that people will worry as much about compliance.
Sure. Thank you.
Federico.
It's a short comment about what Esteban said and what Mariana previously answered, and Javi's related with Javi's question. I think all it's about incentives. When you go to a company to deliver training, if you are not creative enough, your training will be just a check in a box and something without any use after you finish. So I think we should focus there, mostly because the real thing is that companies, they may spend a lot of money and time regarding corruption, compliance, compliance issues, but not regarding antitrust compliance issues, because most of the times they don't, I don't have a budget, I just want you to deliver a half-hour training, half-hour short talk. And the key to succeed, in compliance, antitrust compliance programs, I think it's about what Javi said, incentives and being very creative so as to explain the matters just easily and people understand, and get where to raise a flag when they have to do it. Just that. Sorry.
No, I agree, but and not to contradict myself, but I think that with respect to enforcement, because I think there's also a relation, but there is a cost of not being seen as doing the right thing and being concerned about doing the right thing. So, and what we see now with the interest on ESG agenda, on the ESG agenda, for example, and I think it's also good for the company to be viewed as a company compliant with competition, and also being in some of our countries, this means being at the forefront. So it's not competition, introducing competition compliance is not entirely new, but for certain companies of certain size, it is. Like I'm concerned about being ranking the same level as more sophisticated multinational companies. So having something that fits on the budget, of course, but being viewed as being sophisticated companies compliant with all relevant rules that will be concerned with the key areas of law. I think it's an added. It also has competitive value. I think it's you distinguish yourself by doing the right thing, and also, of course, of preventing a violation.
That's it.
I don't want to make this sound as marketing, but I think in the way it is. I mean, it's even if you don't think that you run the risk of violating the law in the next 3 months, so you can focus on anti-bribery, which is your stronger risk. I think there isn't from a public perception. I think it's good that you gain from introducing a compliance program. And of course, it may not happen in 3 months, but you don't know what's going to happen in 6 months.
Yeah, that's it.
Yes, I have a comment regarding what Federico just said and what Mariana was also talking about now. I think, in order to incentivize also compliance programs, we have to be very clear, I think, with the clients that compliance doesn't work in silos. I mean, you may invest a lot in corruption, but corruption leads to competition issues also. I mean, we all have seen that, and I think this is one way also of convincing them. If you want to have a compliance program, you have to tackle all the angles, because you may be very good at corruption, but in corruption risk, there are also competition risks. You may have agreements with your competitors in order to, I don't know, do a sustainability project that it's great, but you may be exchanging information that you shouldn't be exchanging, And I think this is also a way of incentivizing companies. I fully agree with Mariana about ESG, sustainability, etc. This is another argument. I mean, it may seem naive, but this speech about ESG sustainability, it's getting stronger. I mean, in Europe, in the US, it really appeals companies. And I think this is also a very good incentive, I mean, you have to be sustainable in the long term. And you need to have, if you comply, if you have a good compliance program, you'll have a competitive advantage. And this is also an incentive or a way to incentivize companies.
Yeah, absolutely. And also, I think that, legal departments are always so overwhelmed with what is urgent. I think it's really tough. Or then if you're talking about companies that don't have, of course, compliance division. So it starts usually with legal or with the higher executives. They are swamped with urgent demand. So thinking about this may not be obvious. Also, something else that is not obvious is that the rules change and evolve. For example, many of you may have heard about CADE's investigation, cartel investigation in the HR sector. See, Professor João Bosco Leopoldino here, and he's been, I'm sure, following it together with just the same interest as I am. And this is a completely new subject that didn't exist 2 years ago, and it's something that may impact different areas. So something that CADE used to look at it in one way, it is looking at a completely new way now. And I regardless of the size of your company, I think it's useful for your people to know that benchmarking, which used to be fine in many ways for different sectors, needs to be some measures need to be put in place to make sure that you don't get into trouble. And this is something that we wouldn't have discussed a few years ago. And and if you have a trainee, you will have the opportunity of shedding light in issues that the legal department that is swamped with urgent matters will not have been able to focus on. So it's things change, things evolve. So you need to be up to date, and having a training, a compliance training, will make sure that you will alert to what's relevant at that moment.
I have a
Very sorry. You can go ahead if you want. I mean, I already asked.
the second time.
Twice is enough, I think. You go ahead, and then I'll ask you if you have some time.
My question is related to what Iratzi said, and also to what Mariana has said before. You mentioned, well, there is a trend of an increasing sophistication of compliance programs. There is also a conscience on the importance of compliance by multinational companies based in Europe and United States. At least on my experience, almost all of the compliance programs that we have done at the firm have been related to multinational companies based in Europe or United States. The difference between Brazil and most of the region is that you have such a big size that you have huge companies that are domestic. And the question is, do you see a difference between what those big Brazilian companies request from what the big Europeans and American companies request when hiring you for a compliance program?
Thank you, Julian. There may be some difference, but I don't think that I don't think that any of them are so relevant in the or sufficiently relevant for me to distinguish to establish a pattern. So this is what we see in multinational companies, and this is what we see in large domestic companies. I think they follow more or less the same structure. I think the most relevant difference is which has to do with the size of the company. So if you look at domestic companies, you have these large big companies, and also smaller companies that, because of Lava Jato, because of CADE's cartel enforcement record, started turning to us requesting compliance programs. Between these two companies of different sizes, then I think that I see a relevant distinction. I think the companies of certain size, the differences will have more to do with whether the company is in a sector that has been targeted by CAGI, whether there's a company that has specific risks of engaging in bid rigging or cartel conduct and so on.
Thanks. Javier,
The
please.
type of
Very brief and linked to the previous question and what Irache said before. Compliance in many companies in Latin America is linked to enforcement normally, and enforcement is, how can I say, even in my country, we have less and less enforcement. That's what I'm saying here. Perhaps not in Brazil, but in many other countries, we are seeing less and less competition culture generally and less enforcement. So basically competition compliance is no more than a tick in a box, and perhaps just trainings and no more than that. So how can, I don't know, in your experience or maybe in your opinion, how can we change that? How can we link a little bit more compliance, competition compliance with ethics generally, and de-linked it with the enforcement actions of the government?
I think that's an excellent question. It's I think that well, I don't have one answer. If I had, I'd probably be making money only with compliance programs. But I think that seriously, I think there is the way I see this is. There is the aspect of being. I think there is a cost. Saying differently, what we were discussing in the previous round. I think there is a cost of not being viewed as doing the right thing today, and I think it goes to the point that Irache was making. Like, you have to be compliant. It's no longer cool not to be compliant, and maybe to a certain level, companies of certain with specific characteristics that's not necessarily obvious, but I think it's the point that is important to make. The other aspects, and I've been thinking a lot about this issue on whether enforcement has really gone down, and I don't have, again, a bulletproof answer, but one different way that I'm looking at it is whether things are not just going well. First, whether it's just too small a period in time for us to reach this conclusion, and whether, putting in a different way, if we look at this question 20 years from now, maybe we were looking at a COVID period, 2 or 3 years period, and this will not have mattered. So it's too soon to reach a conclusion that enforcement has really gone down. And the other thing is that we had a peak because of number of international, because of car parts, auto parts, kept us all busy for a number of years, but they were basically talking about parts of a car, right? So, and this led to hundreds of investigation and some other similar investigations. This was a peak. We went, countries in Latin America went from nothing to a peak, and in Brazil's case, and some other Latin American countries, car wash too. And maybe we're reaching a point, I don't know whether it's here, or here, but we're reaching a point where we will have an average number of cases. So I think companies are not making their risk assessment right if they're considering that it was a fluke, it was overrated, no need to worry about this anymore. And I think it's what I try to do when I talk to companies. Say, maybe if you're starting from scratch, maybe you don't need to to spend a significant amount of money, but it would not be the best strategy from your perspective, in my view, not to invest in compliance simply because it's not trending. I think it is trending, and I think it's something that you need to be worried about.
Great. Any other question? Mariana, your final words.
Well, I just want to thank everyone for an extremely interesting discussion. It's I've been thinking a lot about compliance, also in the context of enforcement, and this was a lot of food for thought. So thank you for your comments and questions. It's and I think it's an extremely important agenda. It may not be obviously as sexy as payments, as the digital market, or as new ex-ante rules on digital and on payment methods, but I think it's a topic that must be in the agenda of agencies and practitioners and companies all the time. I don't think it would be good for consumers in general if suddenly competition compliance became irrelevant. So I think it's great that we got together to discuss it. Thank you so much, Julian, for organizing this, and congratulations for all the past events this year of the ForoCompetencia. They have been excellent.
Thanks. We have a last minute iPhone JC. who raised its hand?
Hola, Julián. Hola, Mariana. I'm sorry. I'm Juan Cristóbal Gumucio. I've been on and off, unfortunately, and I'm driving right now. So, but I follow the seminar. Thank you so much for Mariana's presentation. I just have one question. If you, Mariana, or someone else from the floor, come across with issues about legal privilege. What I mean here is that whether the antitrust authorities respect legal privilege, particularly with compliance officers. I mean, as you mentioned, part of this is training, but part of this is also audits, and many times the training ends up with something like, well, if you find a yellow light, you should ask the compliance officer, who usually are lawyers, in-house lawyers, who are dealing with questions, and many times they have to say, no, don't stop doing that, etc. But then if that type of information, correspondence, etc., ends up at the hands of the antitrust authorities, it might be an issue, and actually it may be a big blow for compliance. I don't know if you have had issues like that where this legal privilege is being respected or not. As you may know, in Europe, in-house counsels may not be considered that they are under client attorney privilege. Here in Chile may be different, but not quite clear. And I don't know what is the situation in some other places like Brazil, Argentina. I don't know. That was my question, and I'm sorry that it's the very last minute and with no camera.
Well, thank you so much, Cristóbal. This is this was actually one of the conclusions that came out. Your concern was actually one of the concerns that came out of the survey carried out by Eduardo Pérez Mota and Felipe Arrasabal, that the region lacks sufficient warranties with respect to professional secrecy in compliance. So the scope of professional secrecy could be strengthened in relation to compliance programs. So I think your perception is common. Brazil has well, this is a concern in Brazil too, possibly because of a different reason than in other countries. We, in theory, our rules on secrecy are applies to lawyers in general, so arguably also to compliance officers, but there's no specific rule with respect to that, and there have been some decisions. There are certainly no rules with respect to CAGI on that. And actually, in one of the car wash cases, there was a decision that I believe was later reversed, where the court required that documents prepared by the legal department should be were not privileged and should be disclosed to the judge, because the legal department was acting as an executive. So even though in Brazil the professional secrecy applies to to lawyers in general, even the court has decided otherwise in one case. I think this is an area that must be improved, because there is, talking about the incentives, going back to the discussion on incentives that we had a while before, it's if people cannot who are unable to knock on the door of a compliance officers and have a question, then people will not do this, and so that's certainly not good for compliance effectiveness.
Thank you, Mariana.
Thank you. Good to hear you.
Okay, now without any further questions, and with your final words already said, I want to thank you on behalf of everyone for a very for an excellent presentation and a very generous debate. So I will see everyone, I hope, in next month. We will have a breakfast on judicial review, and Javier Tapia will lead the debate. So I hope to see you then. Okay, thank you very much.
Thank you so much. Hope everyone
Thank
has
you. Have a good day.
Thank you.
Bye-bye. Thank you very much.